Good morning, everyone. Welcome to the session on intelligence gathering, law and regulation. My name is Jennifer Robinson. I'm an Australian lawyer and a member of the Executive Committee of the Commonwealth Lawyers Association and the chair for today's session. Not so recently, it would have been uncontroversial to assert that the government must have a reasonable suspicion of illegality and criminal behaviour and require a warrant before engaging in surveillance. But Edward Snowden made international headlines just 2 years ago, a CIA whistleblower, when he revealed the extent of government mass surveillance by the US National Security Agency and its Five Eyes partners, Australia, Canada, New Zealand, and the four, Britain. Now considered the new reality, academics and lawyers alike have asserted that mass surveillance undermines long-established principles of law, having reversed the burden of proof, effectively placing all citizens under suspicion, raising serious questions about the presumption of innocence, due process, and our right to privacy. Campaigns against the practice rally under the headline, "Citizens, not suspects." This has major significance for the Commonwealth and for lawyers and judges of the Commonwealth. 4 of the Five Eyes partners are Commonwealth states: Britain, Canada, Australia and New Zealand. And as a grouping of nations that include developed democracies, emerging democracies and repressive states, the regulation and availability of surveillance technologies and their use by government raise serious questions for us as lawyers, for judges, and for our ability to defend our clients. Key questions have been asked in the journalistic sphere around how this impacts upon the operation of journalists and their ethical obligations to maintain the confidentiality of their sources. This marks the first time that an international gathering of serious lawyers like the Commonwealth Law Association has given consideration to the question that this raises for our legal professional privilege, our duties of confidentiality to our client, and indeed, I think, the sanctity of the retiring room and the confidentiality of judicial deliberations. Just this year, 2 months ago, the UK government admitted in the IPT tribunal, that we'll hear about a little bit further, that it has been unlawfully intercepting legal correspondence for at least the past 5 years. This is a key concern, I think, for all of us within the Commonwealth, and one that deserves robust and cross-disciplinary debate. I'm pleased to introduce our panel today. Joining us, it's a bit of the Australian mafia at work, so I'm hoping that we'll have spark a conversation and have questions from the floor, a comparative conversation with our colleagues, you all from different Commonwealth jurisdictions. But joining me today, we have Adriana Edmeades from Privacy International. She's a legal officer who is responsible for taking strategic litigation to prevent the sale of surveillance technologies to repressive states and indeed to hold accountable governments for their surveillance practices. Also joining us by video link is Julian Assange, an Australian journalist and author, editor-in-chief of WikiLeaks. But what many of you may not know is who is also an expert on creating anonymity on the internet. He's a published author on the question of surveillance practices and government surveillance. And WikiLeaks has been obviously instrumental in the revelations, including the spy files, which demonstrated the way that Western companies are selling surveillance technologies to repressive regimes. So please join me in welcoming our 2 panellists. Just checking that we've got the technology. So welcome, Julian and Adriana. Instead of having a panel discussion where we allow each member to speak at length, we're going to have this more of a conversation, a matter of question and answer, and a conversation between the panellists. But I'd like to start with Adriana. Given we're a room of lawyers and judges predominantly, could you please set out for us the framework, the legal framework, as it were, of surveillance in the UK here, the legal regulation and the cases that Privacy International has been taking to challenge that practice?
Sure, and thank you, Jen. So my name is Adriana Edmeades. I'm a legal officer at Privacy International. Part of our mandate at Privacy International includes bringing strategic litigation to highlight the current defective legal regimes which govern the security services and also to highlight and seek to halt the global trade in surveillance technology to repressive states. I think in terms of getting a picture of what the current legal regimes are in the UK in relation to the security services, I think it's probably most useful to talk through our most recent case in the IPT. Before I talk that case through briefly, I think there are the two things to note. The first is that it is REPA, which governs, in the majority of cases, the conduct of the security services here in the UK. And the second thing is that REPA requires any litigation against the security services to be brought not in the normal UK courts, but in a particular tribunal called the IPT. So in our most recent case, Liberty and Others and GCHQ, which was brought by Privacy International and a number of other concerned NGOs, there were essentially two issues under consideration. The first was, what does external and internal communications mean in a surveillance regime? And the second was, what is the nature of the intelligence sharing regime between the UK and the US? So turning to that first issue, essentially under REPA, there are two different warrant systems which operate when the security services want to access communications between individuals, and those warrants depend on a distinction on the basis of being internal, being in the UK, and being external outside of the UK. But our point in that litigation was that is a distinction that has significant legal implications, but it's a distinction without meaning. To give you an example, were I to send an email here in the UK to Jen sitting next to me, theoretically under REPA, that would be an internal communication which requires a slightly more arduous warrant system. The security services would be required to satisfy, have more to satisfy if they're to get that warrant to access that email between Jen and I. However, the nature of email communications and communications over the internet is such that that email going from myself to Jen is likely to exit the UK, to go, for instance, to California, and then ping back to Jen, such that the security services, if they want to access that email, no longer have to satisfy the slightly more arduous requirements under an internal warrant system, but can avail themselves of the warrant systems that apply to external communications, which means that they no longer have to specify a person or a premise. They can avail themselves of a warrant which essentially gives them a carte blanche to access whatever it is that they want. So that was one of the issues at play in the IPT case, and we can talk about the implications of that very permissive warrant system later. The second issue at play was, what is the legal regime governing the transfer of information between the UK and the US? And what the IPT held was that there was that the UK was in breach of the law because there was no published legislation or guidance in relation to the information sharing between the UK and the US. Now, what does that mean? That means that if they wanted to access that email, that lawyerly email between myself and Jen, and they didn't want to either use the internal warrant system or the external warrant system, it may well be that via their intelligence sharing regime with the US, they can get that information without having to satisfy any of the internal legal requirements. So again, it's another extremely permissive way for them to access communications between individuals here in the UK. And what the IPT held was that the UK was in breach of the ECHR because of the fact that there was absolutely no published legislation or guidance dealing with that arrangement between the UK and the US. So I think there are significant and big issues at stake here, and I think that's a good case to open up with.
I want to ask you particularly about the Belhaj case, which is the one I referenced in the introduction, where the UK has actually admitted that they were surveilling legal correspondence unlawfully for a significant period of time. Let's talk about the questions that raises. Can you tell us a little bit more about that case and what that means for those of us who are taking cases against government, and the specific allegation made in that case that the government was surveilling lawyers' correspondence with their clients in order to gain the upper hand in proceedings?
Yeah, sure. So that was another case that was brought in the IPT, and the IPT is a weird beast whereby you litigate by way of assumed facts, but the security services will neither confirm nor deny in open hearing what the situation was. So Belhaj proceeded on the basis of hypotheticals. And so we don't know we're yet to have the closed hearing on whether or not the claimants in that case and the lawyers, whether their communications were in fact picked up by the security services. But what we do know from the open hypothetical hearing is that the UK had no provisions and no way of dealing with confidential communications between lawyers and clients. So in the same way that they had no legal regime to deal with the information that they got via the UK-US intelligence sharing regime, similarly, they'd never turned their minds to what they do with information that that legal privilege might attach to.
Now, I want to now go to Julian briefly. I joke that Julian is the most lawyerly non-lawyer because he's dealing with so many different legal proceedings around the world, and I think is now up to, at last count, 150 different lawyers in different jurisdictions dealing with all manner of legal questions. But I want to focus more on this question of what surveillance means for journalism and for control of information, and as that rolls out for lawyers. So we talk about the need to protect our confidentiality with clients, and for journalists it's a matter of protecting sources. Is it possible for us? What is the capability of government? What is it that we're coming up against as lawyers and judges? And how does that impact, in your view, the ethics of how we manage our practice?
Thanks for that question, Jen. Okay, so WikiLeaks is a multinational media organization, and because of that we're operating in different jurisdictions. We have many cases in those jurisdictions, some offensive, some defensive. Criminal cases that are offensive, criminal cases that are defensive, for example, in the United States. And what has, in part, kept us going is this extensive network of international lawyers that we've built up. Now, I've had many years of experience in studying the National Security Agency and fighting various policy fights since the 1990s to reduce the amount of surveillance the National Security Agency and similar agencies in the Five Eyes and in other countries even are permitted to engage in. Back in, if you want to understand the threat to lawyers, well, I come at it through understanding the threat to our lawyers, who are involved in various forms of sensitive and strategic litigation that can be upset by surveillance. So first of all, let's understand where all this is coming from. The Five Eyes Alliance has been around since the 1950s. It has engaged in secret relationships with many different intelligence agencies, some 30 around the world, to share information. The aspect which is run by the United Kingdom, GCHQ, is run under the Foreign and Commonwealth Office. In fact, the person who is, as of a month or so ago, being made head of GCHQ is Robert Hanningham. Robert Hanningham was in fact the case officer for my asylum dispute with the Foreign and Commonwealth Office immediately before moving to GCHQ. That is how close the relationship is. So it's not simply the case that these agencies are concerned with terrorism. In fact, the majority of their work, if you look at internal documents that have been revealed in the Snowden revelations, is in fact about geostrategy. Now, and that has been the case for a long time. In fact, we can go back to prior to September 11, where I wrote an article for the London Independent in 1999 examining National Security Agency patents. Because while Edward Snowden's revelations have been critical in drawing attention to these issues, various researchers and former National Security Agency whistleblowers had been talking about this really, in fact, since the 1970s. But looking at things like patents, for example, you can get you could get a bit of an understanding into what these agencies were doing. Having such a massive budget, more than $50 billion a year being spent by the National Security Agency and associated services, this is an economic footprint which cannot be concealed, even if there is perfect security in relation to their classified operations. It leaks over into things like patent applications. So back then I posed the question, will soon enough all our telephone calls and emails be archived in the bowels of a foreign spy agency, indexed and be searchable forever? Now, back in 1999, that was a question, principally because the automatic transcription of voice was new. And while the National Security Agency and GCHQ and the various agencies that were feeding it the world's information at that time were collecting en masse, they were not able to search this information en masse because of the complexities of searching voice telephone calls. While you could search the metadata for these calls, the actual content was hard. But around that time, the NSA found what it was referring to inside for 20 years as its holy grail, the ability to machine transcribe human speech. Now, as time went by, the societies of the world have moved their internal and external operations onto the internet. That's been combined with machine transcription. And so this is not a matter of are these agencies spying on individual people without a warrant, targeting particular people, and lawyers' communications without a warrant. That is not how they see the world. The talk inside the industry is of strategic interception, that is, intercepting the bulk communications between one state and another, one geographic region and another. For example, 98% of Latin American telecommunications pass through the United States, where they're intercepted by the National Security Agency. And this, playing the game of numbers, is a strategic game. What it means is that there's not a situation anymore, really, of people being on surveillance target lists, although there are such lists for extra intensive surveillance, but rather that everyone is being surveilled all the time. And because so much information that we are engaged in human society, whether it is personal or economic interactions, or whether it is development of legal cases, these are all swept up in this great vacuuming apparatus, which has been established for many years for geopolitical considerations, strategic considerations, and which has been empowered even more as a result of September 11. Now,
I just wanted to I wanted to ask you to describe in more practical terms for the lawyers, because one of the conversations that I've been having with many different lawyers that are here in the room and elsewhere is the lack of understanding within the legal community and the broader public around the capabilities. So what exactly does this mean for an individual using their phone, using their email, for a judge or for a lawyer? What does it mean exactly? What is the technological capability, and then how do we then think about regulating that?
Well, the capability is that essentially everything every communication that occurs to US servers has been intercepted. Every communication just about that passes through Britain, and many of the Commonwealth countries route some of their interconnects to Europe, for example, through Great Britain, is being intercepted. Now, the forms of communication, SMS messages, for example, are very easily indexed. This is something that, the changes in the economic relationships between how much it costs to transmit and how much it costs to store, that means these can be indexed and stored forever now. Other forms of communication, file transfers and email attachments and so on, are preserved for a shorter period of time to understand whether they should be preserved for a longer period of time. So even if you think you're engaging in communication with someone else where that communication doesn't pass through a Five Eyes country, the Five Eyes Intelligence Alliance of the Christian, white, British-derived countries of Australia, New Zealand, Canada, United States, and Great Britain have intelligence sharing relationships with many others. So that collection occurs for, most of what lawyers do in practice, using Google, for example. Google has a relationship with the United States government through its prison program, but also information is often collected in bulk as it goes in, as it passes these national borders. It is if we can pull back for a moment, if you have an Android phone, which most of you either have an Apple or Android phone in this audience, as soon as it's activated, as soon as it's turned on for the first time, it communicates back to Google. It communicates your web searches to Google. It communicates your locations to Google. And the same thing with your clients. Those emails are going there and so on. Now, this is not just about, you go, okay, can they use this information in court? And I think this is actually where the real legal challenge is at the moment. The possible fight back against this activity is, can at least this audience prevent this sort of unlawful, or at least unregulated, intelligence activity being used in court to convict people? And the answer is possibly yes in some cases, but if we look at what has been done, how this has evolved, for a number of years now, we've been trying to explain to people about parallel reconstruction. And parallel reconstruction is when the intelligence services feed unlawfully obtained information to, for example, the for example, the DEA or the various police forces or other aspects of government. And they feed them that information and say, but you cannot use this in the case. You cannot enter this into the court record. So you must find another way of reconstructing the same information. And that is, in fact, a formal policy of the DEA, where agents are advised to engage in parallel reconstruction for material provided by the National Security Agency. So I think really this is a whole world which most people in this audience will not be familiar with. When we talk about the international system and international diplomacy and international law, what is often referred to in political theory as the anarchic international system. But intelligence agencies, similarly in their mass electronic spying, are operating in this anarchic space.
And that's something that I wanted us to talk about today, which is the
secret space. Because it's a secret space, they have extra ability to engage in this, and they have always done so. These are, in fact, piratical organizations, and we can go back and look at the history of piratical organizations. That is how they operate. They're used to operating like that. When they are flushed out, they use their political might, usually to change the law to make what they were previously doing legal. And that's what we've seen mostly here in the United Kingdom and also in the United States.
I'd like to pick that point up because I think there are two important points that come out of that. And the first is the difficulty of regulation when we're talking about cross-jurisdictional intelligence gathering, and in particular the problem of what Alan Rusbridger has described as arbitrary regulatory arbitrage, rather, where domestic systems of regulation that we traditionally have applied to intelligence servicing and policing and the gathering of information for the purposes of criminal proceedings are subverted somehow by this global intelligence sharing arrangement. So it may well be, and perhaps Julian and Adriana can speak to this more, that the US could be surveilling me as an Australian citizen living in the UK without the use of a warrant, potentially, and sharing that information with other governments for the purposes of their own intelligence gathering, effectively allowing governments to get around what previously existed in terms of regulation. So I wonder if each of you could speak to the problems of regulating this cross-jurisdictional intelligence sharing, and also to the point about recent cases on this point.
Yeah, sure. I mean, I think Julian's point that currently, as it stands, it's an anarchic system is a good one. And what we have here is whilst we might have novel technologies with extraordinary capabilities, the principles of law that we want to apply to these technologies to regulate them are not novel, they're not radical principles, they're very old principles that have been developed up to regulate the conduct of agencies within democracies which are afforded extraordinary powers. So I think, as back in 1984, for instance, a case was brought about the security services and the police's capabilities to use wiretapping on phones. And in that particular instance, the security services and the police told the population that it was a type of technology and a type of activity that shouldn't be regulated, that shouldn't be subject to judicial or legal oversight, that they should repose their trust in the security services in these agencies. The ECHR heard the case and held that, that there should be a proper statutory basis for that type of conduct. Now, that is something that we all accept as a pretty uncontroversial idea currently. And what we at PI and others like Julian and Snowden are advocating is that the same principles of law, very uncontroversial but very significant principles of law, should be applied to regulate the conduct of the security services in relation to this new technology, new technological capabilities in relation to email and phone surveillance. So whilst some might suggest that this is a radical proposition, that it's an anti-security state proposition, it's not. It's a very, in fact, conservative and modest ask that we're making, which is that this new technological capability be subject to old and well-established legal principles to properly regulate it. And to link whether the system is anarchic and the difficulties with regulatory arbitrage, I think the point is that the UK, the US, other members of the intelligence sharing arrangements need to properly consider their role in the international community in properly regulating domestically what it is that they do to limit the kind of anarchic, endless possibilities of surveillance out there.
And if I may just ask, what has been the response of the British authorities after the admission in the IPT tribunal that they were surveilling legal correspondence unlawfully without any sort of guidelines? Have there been any efforts towards reform? And what could we be asked, what should our lawyers hear from different states around the world who, I mean, we're not just talking about the UK and the US, Nigeria, Kenya, other states that may well have the same capabilities. What sort of questions should be being asked in those jurisdictions?
The same questions that we're asking here. I mean, the UK's response to the suggestion that as a matter of law, they should publish law and guidance in relation to how they deal with information to which legal privilege attaches has been extraordinarily cynical. It's hardly even been acknowledged by them as an issue. The whole idea, and in fact, it wasn't something that they identified and self-policed. It took a bunch of very poorly paid pinko lawyers to identify the issue and to bring the case in the first instance. If we're happy giving all of these powers to these security services, if we're happy to repose our trust in them, the least they can do is identify when they're doing things like providing themselves with the capabilities to access information that legal privilege attaches to, but they're not. And had it not been for lawyers working hard, working late into the night, and identifying that there was no guidance and that they had these capabilities, this information wouldn't even come to light. This is not an agency, this is not an institution that we can simply repose our trust in and trust that they will identify the deficiencies and the difficulties in how they operate.
I will open this up to questions shortly, so for those of you who would like, both Julian and Adriana are happy to take questions, so if you'd like to come down to the microphones, I'll begin with questions from the audience shortly. But just briefly, knowing now what we know, Julian, about the extent of surveillance and the reality that we now face, journalists have been talking a lot about their ethical obligations to protect sources, and that it is now their obligation to use certain technologies like encryption in order to properly protect their sources. I haven't seen similar conversations being happening in the legal community around what it means for us in terms of our obligation of confidentiality to clients. What does it mean, and how can we better protect ourselves and our clients?
That's a very good question. Legally, in the United States, it has been revealed, and in fact General Alexander has said publicly, that the United States government will intercept any lawyer-client communications. That's not a concern to them. The Australian government has also intercepted such communications in relation to oil negotiations in East Timor. And that only if there is a criminal indictment, not investigation, but a criminal indictment, at that point there will be a flag that those intercepts should not be fed to the Department of Justice from that point on. Of course, parallel reconstruction, however, is still possible. Now, what should lawyers do? Well, we have a lot of lawyers, and we've had to kind of drag them kicking and screaming into using various forms of technology to protect their communications with us. But they have done so, and you know, it's not so hard. You can learn this. You can learn this stuff. If you can learn you know, suffer through law school, you can certainly suffer through a week of getting familiar with how to encrypt your phone calls and encrypt your emails and engage in encrypted chat. Now, that said, none of this is perfect if you are individually targeted, but this is a matter of raising the costs from a generalized interception system, which is intercepting all or nearly all cross-border telecommunications flows all the time, where intercepting you is zero marginal cost, to going to a regime where most of your communications are encrypted, and to get through that. Modern encryption can't be broken by the National Security Agency. The academic science is very well established. But if you are individually targeted, so even if your computer is encrypted or your phone is encrypted, then they can break that, and then the encryption is worthless. But that costs a lot. And that also leaves a paper trail, because someone has to sign off on individually targeting you. And that paper trail, in fact, if you get hold of it, might become helpful in your cases later on down the track. Now, just a very simple list of some technologies you can use. You can use at a sort of, if you have a technical person around you, they don't have to be too technical. You can install something called Tails. This is quite good. This makes it hard even if they do try and attack the machines you're using it on. It's its own operating system. It has these built-in things. It boots from a USB, so you don't need to wipe out your computer. You can search for that. Tails and Tor. Tor is an anonymous encrypted relay system that encrypts your communications as they go out. So if they're spying directly on you, they're not going to see what you're communicating with. And that also has something built in called PGP, which is encrypted email. Now, we have become quite wary against that, because actually so many people get confused with using PGP. But the way it's implemented in Tails, it's not too bad. But this is not just about technology. I think over and above that, because any technology can be flawed, is a sort of human operational security amongst lawyers, which is understanding what are the time-sensitive, secretive parts of your case, where the opposition, if they knew about it, could take steps in a reasonable period of time to use that information in a parallel reconstruction attempt or in another attempt to somehow thwart your ongoing legal proceedings. And that's a matter of compartmentalization, reserving that which is of supreme importance to be communicated in person or communicated on notepads. I've dealt with a lot of counterterrorism lawyers, and most of those, for example, Gareth Peirce, they understand how difficult this game is, because they've seen many clients where, the people with telescopes are lip reading the client's conversations with the lawyers, for example. So writing information down on notepads, using code words to increase the cost, using assumed context where there's it's going to be harder for someone else to follow these conversations. The other day, we just had an interesting legal meeting, and I was quite concerned. We had a lot of lawyers, whether here in the embassy, which has it admitted the £15 million of surveillance in the last 2 years by the British government of me here, whether we could keep this communication secure. Now, I understood that me and my lawyers, we only just understood what our case was about. We only just understood the approach because it was so complex and fast-moving. So that's another way. Can that complexity in your case, you've got to think about it when this goes through intelligence officers. Can they understand it? Will they know how to route that information appropriately to the appropriate lawyers? And then you often have the actual lawyers involved in opposing you, they may not want to be contaminated by this information in many cases. So only general guidance might be given, for example, if you're litigating government department, to those lawyers, not precise information. So you can play these games strategically to defend the integrity of the case that you're taking, not just using electronic techniques, but using techniques of complexification, compartmentalization, understanding what is time sensitive, and understanding what are the critical elements of your case.
Thank you. I'd like to open up to the floor for questions, if anyone in the audience would like to ask either of our panellists. No one's game? I'm sorry, if you wouldn't mind just going to a microphone so that everyone can hear the question.
My question is for Julian.
And I'm sorry, could you also just, if everyone could announce their name and affiliation?
My name is Alexander Lurch. I'm a reporter for the Daily Mail. My question is for Julian. Why do you feel that there is such apathy with society in general towards government surveillance? It appears that it is being pushed into our face, and yet the majority of citizens seem to have no real care or contempt for its practices. Now, why is this?
Well, there's quite a bit of discussion that has gone on, so I wouldn't say that entirely. Here in the United Kingdom, something particular has happened. You can do the interesting thought experiment. What if it wasn't only The Guardian that was publishing about this issue? The Guardian owned this issue. Now, in my position of WikiLeaks, strategically, the proper thing to do to make this a national debate here in the UK was to share that information, perhaps in a limited extent, but nonetheless share it with the Daily Mail, with the Telegraph, and so on. But because of these competitive rivalries, The Guardian hogged the story, and so no one else wanted to feed territory The Guardian already owned. Yes, the intelligence agencies are also influential, and I would say here, this debate is not a matter of the rest of the society versus the establishment. That's not what's going on here at all. I look at it in a very different manner. Of course, we have elites in every society. And of course, those elites want to protect themselves and protect their position and emancipate their position. We have something developing here, which is basically the security guards of society. And that's what they are. That's what they're meant to do. They are security guards. We're letting the security guards take over the party. And that's not something that is going to produce a good result. We have to have the people who understand the complexities of the rule of law, the complexities of government, and the complexities of producing a good society, managing and controlling the basic processes of society, not secretive security agencies and contractors who don't understand these things and who have unlimited appetites. The other reason why this debate is not, it doesn't have some of the strength that it might. Actually, it's a very complex thing. We're talking about extremely sophisticated, secretive technologies that are hard to understand, that are invisible, that are, in all intents and purposes, intangible. They're almost like religious claims, which people have a natural and correct skepticism of. When people tell you, you must change your life, you must change how you live, you must change how you operate as a lawyer, as a journalist, because of this claim about something that is invisible and intangible and complex. Most people have a natural skepticism into believing such claims until they see the proof for themselves. In our business, because we have been spied upon by GCHQ, I've been on the NSA manhunting list that came out in the Snowden documents since 2009. We feel this keenly, and I understand the complexity because I'm a technologist and I have a background in cryptography. Other people don't. I think perhaps it is akin in some ways to the debate about climate change and whether this is something we're able to understand and deal with. Climate change is complex. Specialized scientists understand it. And for the rest, it's essentially a religious claim. That is why it is really important that specialists in the rest of society who understand long-term processes take this in their hands and not leave it simply for what is in effect society's security guards to develop.
Thanks, Julian. We have another question.
Thank you. I'm Alex Ward from Australia, and on the interception, if the Americans read my inane emails to my friends, that's their loss as far as I'm concerned. But my horror sitting here, the question to Adriana is, what should lawyers be doing? Because now we're more and more using this technology. I'll always email my opinions my instructing solicitors. Well, now you've horrified me, because am I giving them to the world? So what should we do? We're all using it now. How should we protect ourselves?
I think it's an excellent question. And as you say, you know, the idea, and it links, to, I think, to the Daily Mail question and Julian's response, to some extent, the harm is abstract, right? I send multiple inane emails every day. If they want to trouble themselves to read it, so be it. But the reason that we should care is, as you say, what happens when we're conveying information that relates to our professional lives. I mean, I think we should care anyway about the inane emails, but let's say where it bites is where we understand that the professional advices are being transmitted and being picked up in a situation where we currently have no legal regime to regulate what's being done. So I think the answer is two things. I think the answer is we continue to bring cases, we continue to advocate for law reform. I think we all need to go back to our bar associations and make this an issue, make this something that's not abstract, but something that affects our profession and is something that we can apply pressure for reforms on. But in the meantime, the fact of the matter is both your inane emails and your advices are being picked up, and there's currently no proper regime to regulate the use, the access and use of that information. So in the meantime, Julian's right. We all need to use encryption and other technological methods to keep that information from being accessed.
Please come to the microphone.
David Lees from the Herald paper here in Scotland. I'd like to ask Mr. Assange a simple question. Do you think that Scottish nationalists were paranoid to think that the security services took an interest in them during the referendum last year?
That's a very interesting question. No, they were not at all paranoid to be concerned about that. Now, that said, we haven't published proof that they have been involved.
I'm sorry, would you mind repeating the question? I think there are some in the audience who didn't quite capture it.
I was wondering whether Scottish nationalists were paranoid to think the security services were taking an interest in their activities during the referendum in Scotland last year.
Scottish nationalists were correct to be very concerned about that issue. Now, they're correct for a number of reasons. There was a cables published, I think it might have been by the Scotland Herald, by one of the Scottish papers, beginning of last year, where the British Foreign and Commonwealth Office had engaged in correspondence with approximately 30 other states, trying to bring their pressure to bear to influence the Scottish referendum result. And as we led up to the final weeks of that referendum, you will recall that the Swedish Foreign Minister, Carl Bildt, to those people who follow these things, a hawkish transatlanticist from the 1970s. We have published cables from the 1970s where he first came in contact with the CIA, coming out and saying how Scots should vote. Similarly, Barack Obama called in to say how Scots should vote. And that reflects, if you look at that cast of characters, that reflects a transatlantic concern with what is happening with Scotland. Now, the UK Treasury made a report on what happened in Scotland. And, sorry, the UK Treasury made a report about economic scenarios for Scotland post-independence. It was criticised as being partisan for that report. And the Treasury came out to defend itself and said that, well, it is not partisan, that its partisanship is acceptable. It is in the name, Her Majesty's Treasury. So this attitude of the UK government in saying that this is an issue of state, it is a national security issue, that the Scottish independence movement is, in effect, a threat to the state of Great Britain, which is clear from that response by the Treasury, means that the full capacities of the GCHQ, for example, can be deployed. That said, it's not quite so easy. There are many Scots employed in these agencies, so the care has to be undertaken because Scots in those agencies may well reveal what has been done, as they did reveal that information from the British Foreign and Commonwealth Office going out across the world to lobby other states to influence the result.
And we have a second question at the back.
Good morning. My name is Muhammad Shafi Abdullah. I am a practicing lawyer in Malaysia and currently the chairman of the ASEAN Intergovernmental Commission for Human Rights, and therefore my interest in this particular area. Can I direct this comment as well as a short question to all members of the panel? I think in relation to whether, how we deal with the court in relation to admissibility of illegally obtained evidence, as you have suggested, I think that can be well regulated if at least the Commonwealth countries, the judiciaries in the Commonwealth, would have a common front in relation to policy or judgment. Now, we have in the background looming in the judiciary, namely the principle that illegally obtained evidence can still be admissible, with one exception. And that is very well taken up, if I'm not mistaken, by Nichols QC in Ireland in a case called Trimboli, where the Supreme Court of Ireland held that general principle is cast aside when authorities consciously and deliberately violate one's constitutional rights. Now, this seems to be quite clear in the context of what you are saying. If the intelligence authority, knowing well that they are consciously and deliberately violating one's constitutional right, and in this case, it would be right to life, liberty, right to a fair trial, this principle can be used to, in fact, exclude such evidence. In short, what I'm saying is, it can be better regulated in court rather than outside of court. But that is only when you see the light of day in court, when matters comes to the court. But when matters do not come to the court, you have 2 or 3 problems that I can see, and I would like to invite your comment on this. One is the nature of intelligence gathering agency, a kind of police network. The nature of such agencies is to keep everything secret and to keep everything non-disclosed. It's almost the nature of Scorpion. You will never be able to penetrate, because as soon as you invent a new policy, there'll be further policies or further invention that will make you, again, 4 to 5 steps behind them. Second is this confusion that we have that cloud our mind, because most of these technologies have got two uses. One is the abuse, the other is the positive use. And that seems to cloud a lot of members of the public, especially public authorities. Like, for instance, I'm involved in advising at least my government in relation to encrypting messages between embassies. Now, in the light of that, I come to know that if you do surveillance in the emergency services, we call it a 999 in Malaysia, I think you call it by another number, there is a collateral service where one can locate within a 50-meter radius of the existence of a person who needs the emergency help. And it is not merely vertical, it is horizontal as well. That means you have got an X and Y to precisely point, even if he is in the 88th floor of a building. Now, that is how precise information is for a positive purpose. Mr. Hassan and members of the panel, could I inquire, what kind of hope can we ever have to regulate such an unregulated practice in the intelligence agency? I find that it is almost impossible unless you see the light of day in court when those matters appear in court. Thank you.
That's a very good question. You are absolutely correct. These are inherently organizations which operate in this piratical international environment. It's in their DNA to evade the law. They have been evading the law. Creating new laws, well, they're going to evade them as well. But that said, you can't, in the fight for a rule of law in society, you can never consciously and publicly give up ground. You can't just abandon the ground, even though you understand that it might be very hard to hold on to, because it will immediately be occupied, and then some new aspect of society will be bitten off by these groups who behave in this manner. I think, as far as I'm concerned, if we look at the long game, these intelligence agencies have been operating in secret. The basic technology is in their favor. Every 18 months, the cost of storing communications halves. Every 2 years, the cost of processing communications halves. In a competition with that geometric growth and the lesser growth of the human population, it's clear which growth is going to dominate. The ability to collect, store, index, and process communications, which is essentially already overwhelmed human communications by the Five Eyes Alliance, but is nonetheless moving into smaller countries now. So we're not going to be able to properly thwart the appetites of these agencies. The best we can achieve, and it is an important thing, is to try and check their spread into the exterior society. Try and check that mass surveillance of society from impinging directly upon things like criminal cases, civil litigation, etc. Now, that said, if you look at what is happening in practice, so to begin with, let's go back 10 years. You have, yes, mass interception by the Five Eyes Alliance, and that information being fed to Foreign Office and the Cabinet and the Presidency in relation to various international negotiations, to the biggest companies, the biggest oil companies, the biggest arms companies, the companies that are proximate because they are contractors for this industry. It's like Booz Allen Hamilton, for example, the National Security Agency, 80% of its budget, in fact, goes to these private organizations. So they're literally running bits of the National Security Agency. So they get their snout into this information trough before others. Okay, but as time has gone by, that information is now broadening out into its flow of which or other organizations get it. There's now more than 1,000 contractors working for the National Security Agency. This information goes in forms of parallel reconstruction or directly to the DEA, to tax office. And here in the UK, there's views that, in fact, RIPA has been used even by city councils now. I think this is what we must keep a check on, which is the enmeshing of the other organs of state and of society with these unruly, uncontrollable, secretive intelligence organizations. Lest the whole society be contaminated by that, by their behavior. Now, you ask about opportunities. Actually, I have thought there's some quite interesting ones. For example, how many people on death row right now could be cleared as a result of information held by the National Security Agency? How many people in British prisons could be cleared right now as a result of these databases being held by GCHQ? If we are going to go to the point where city councils are able to access telephone call records without a warrant, then let us get to the point. Let us get to the point where lawyers, in their cases, can get hold of this vast reservoir of information and use it to fight the cases. Now, I think people should be doing this right now, preemptively, in their cases. asking GCHQ or the organizations in their states to hand over that information. Now, of course, they'll refuse. They'll say whether we have the information or not is a national security matter. But down the track, the fact that information was not handed over, which could have cleared your client, or which could have made a material difference in a lawsuit against the government, down the track, perhaps that they did not hand it over at the time that you asked for it, may make a material difference in reopening a case.
Now, unfortunately, now all the hands go up as we're running out of time. If you want to come to the microphones, I'll see if I can take liberty for a few more minutes before I offer our panelists the opportunity for a few concluding comments.
Question for Mr. Assange. My name is Mike Wade. I work for the Times. I wondered, you've been 1,000 days in the Ecuadorian embassy. I wonder how you were feeling after all that time, and what's your relationships like with your hosts, and whether you think you will return to Sweden for trial.
Well, this question is off topic, so I only want to answer it in a very short manner. First of all, I've been detained for 4.5 years in one form or another in this country without charge. I'm not British. I'm Australian. I have nothing to do with this country. I was here to brief the Guardian newspaper in relation to the publication of our materials. Similarly, I have nothing to do with Sweden. I was in Sweden for a week in order to give a lecture on the first casualty of war being the truth in relation to Sweden's involvement in the war in Afghanistan. Right now is a sensitive moment for me. At the beginning of this year, it was revealed that Google had handed over in the ever ongoing US investigation against us, the largest investigation to a publisher, it is believed, in history. The charge types in the United States are espionage, conspiracy to commit espionage, the Computer Fraud and Abuse Act, which has a mini espionage act included within it. It is otherwise effectively computer hacking. And conversion, the theft of government secrets across interstate lines, and general conspiracy. These are very interesting charge types. There's 45 years across the lot, but the final indictment would probably have more. They're interesting for this reason. I have nothing to do with the United States. I'm an Australian citizen. WikiLeaks is not a US publishing organization. We don't publish from the United States. Our people are predominantly in Europe. How is it that the United States is claiming jurisdiction in this case? How is it doing that? What does that mean? Well, if you look at how a media organization works, someone in the media organization gets information and it flows through the other journalists in the organization, through the editors, sub-editors, lawyers, through the technical people who run servers and so on. Now, the United States has a sort of extraterritorial regime, which it runs from Alexandria, Virginia, to reach out into the rest of the world with its laws and apply those laws to the rest of the world in an ever-increasing manner, in more and more circumstances. And in that manner, effectively annex parts of the world because it is able to control behavior. It is subverting, in effect, the monopoly on the use of force in other states. And through this notion of conspiracy being coupled to the workflow process of a media organization, it is able to engulf the employees and owners of foreign media organizations just through one claimed publication of something related to the US defense. I think that is a really extraordinary situation. Now, on the 4th of March, we had a case, maybe of interest to this audience, in the United States, trying to pull out some of the contours of that US investigation, whether there had been unlawful activities conducted on WikiLeaks. That case was brought by EPIC, the Electronic Privacy Information Center in Washington, D.C., on our behalf and the behalf of people associated with us. Now, the United States has been blocking these cases. It's appealed up to the federal court. And how do they block it? Well, they claim this is an ongoing national security investigation, pending prosecution, et cetera, et cetera. Well, it's important to have that in black and white. But the argument used by the judge to not investigate, to not look at the documents held by the DOJ National Security Division is the following. Quote, sorry, let me get this straight. It is necessary to show, quote, appropriate deference to the executive in matters of national security, unquote. This is a federal court judge in the United States. We wanted that federal court judge to review the material collected by the Department of Justice National Security Division to understand whether that was a lawful investigation or an unlawful investigation, whether in fact it had, whether various US agencies had overstepped their surveillance powers. Now they have taken information from Google, in fact even from Jennifer Robinson right here on the stage, emails sent by her. 3 of our journalists sucked up in this. It was revealed just earlier this year. That is an extraordinary thing to see the judiciary saying it is necessary to show appropriate deference to the executive. In fact, that's the whole point of a judiciary, to have an independent branch of power that does not need to show deference to the executive, but that in fact needs to understand the executive and to be a check on executive power. Now, in relation to the broad array, well, we have literally dozens of cases across the world in different jurisdictions, offensive criminal cases that we have taken against these unlawful intelligence activities in Sweden, in Iceland, in Denmark, in Germany, cases to do with the US banking blockade.
I'm sorry, Julian, I'm getting the time called, so we have to, unfortunately, call the proceedings to a conclusion. I'd like to thank, I'm sorry for our last questioners that I'm being told no more time. I'd like to thank both of our panellists for joining us today. This is obviously a key issue which will be affecting lawyers and judges around the Commonwealth, and one that I hope will be the sparking of conversations with your bar associations and judicial organisations around how we can better protect ourselves from these unlawful practices. But please join me in thanking both Julian and Adriana for joining us today.